All right. So picture it. All right. You're in jail. The bail's been set. Let's say it's $1 million. And your supporters, your followers, your fans, your community, they all rally around you. They open up a crowdfunding campaign, and within days, boom, $270,000 pours in. So you would think that you're good, right? You would think that you're about to go home. Well, as we have seen in the headlines right now, wrong. And I'm going to show you why, and I'm going to show you the line of cases that led to this, okay? So just recently in a Tennessee courtroom, like a couple weeks ago, a judge told a defendant, hey, you know that money that you raised? You cannot use it. Not a dollar. It cannot go towards your bond, right? And the reason that the judge is allowed to do that traces back to a particular case out of New York in 1966. But this area of law has been developing since long before that. That case in 1966, that New York case, it was a drug case. And the case was called United States versus Nebbia. And that case answered a question that had never been answered in the law before. All right. So you guys, my name is Gray, and this is my channel, Counsel Gray. Thank you for stopping by, and thank you for coming back if you've been here before. And welcome to any new subscribers that I have. All right. So today we're going to talk about a line of cases that gives judges and prosecutors the power to look behind your bail money, right? All of it, every dollar, every source. And they can say to the defendant, before we accept this money as bail, prove that the money is clean. So here's the thing. The way this doctrine plays out in real courtrooms every single day is very different from what we're seeing in the Chud the Builder and the Carmelo Anthony cases. Okay, first of all, before we get into that, I want to talk to you about what do I mean when I talk about the lineage or the genealogy of an area of law. Okay, the lineage of an area of law is all of the cases that have come before it that have kind of worked together to define a particular area of law. Because we didn't just get to this law. We didn't just get to this judge saying you can't use this money as bail money. There's been a host of things that have happened. And when I say genealogy, that's because these different lineages of law, they marry each other. They come together, they overlap, they intersect, they have babies, and that becomes the genealogy of a particular area of law. The first case that we're going to talk about, this case happened, this is a crazy case, okay? The first case we're going to talk about, this case happened in 1889. So what is that? It's 135, 140 years old. And in this case, this kid, Elmer Palmer, right, a New York kid, he was 16 years old, and his grandfather, right, he was the favorite grandchild. His grandfather had created a will where he left all, or the vast majority, say 95% of his money, he left it to this kid, Elmer, his grandson, Elmer. Elmer gets wind through the family grapevine, I guess. He gets wind that his grandfather is about to cut him out of the will. Now, his grandfather also lives in New York. He's very wealthy, right? He owns a farm. He has a lot of things. Personal property, right? He's got a will that leaves all of this to Elmer. Elmer finds out granddad is about to change the will. So what does Elmer do? He goes and he poisons his grandfather. He was not going to let his grandfather change the will and cut him out of the will. So he poisons his grandfather. Grandfather dies. Elmer still gets all of the inheritance because at that time, there was no law against inheriting from the person that you killed. Now we know this is ridiculous. Like no court would ever say, hey, if you kill your parents, you can still get all their money. Hey, if you kill your grandfather, you can get all the money. But at that time, this is only 130 years ago, right? So we talk about how fast the law moves. 130 years ago, you could kill a relative and still get the life insurance, still get the will, etc. Right? Until this case. This is what happens. Okay, so Elmer is set to now inherit the money from the grandfather that he just killed. Well, his aunts, they get together and they sue and they say that it's not fair that Elmer gets all this money. And that was actually a legal question at the time. It was actually something that nobody had ever thought about. Hey, should we stop people from inheriting from the person that they just killed? Now, obviously, right? No, you can't do that. Okay, so this court, it goes to the New York Court of Appeals. That's just a higher level than the trial court. Two of them said that he should get the money. Right? Two of these judges were like, let him have it. The other five, fortunately, they decided that Elmer does not get the money. From that case, we get the language, and you may have heard this, right? This is the famous quote in legal circles, right? No one, and this came out of this case, right? No one shall be permitted to profit from his own fraud or to take advantage of his own wrong. Now, that's not a statute at that point. It was just a case. The case simply said, if you kill your grandfather, you cannot inherit his money. So it's also not in the Constitution, right? It's not in the legislation. It's not in the Constitution. So it's basically just what the courts call a maxim, right? It's not fair for you to kill somebody and get their money. Now it's obvious. In 2026, it's obvious. You cannot keep the profits of your crime. In that case, the inheritance was the profit. And ultimately, the court said no, because the lower court said, sure, let him have it. The higher court, they were split. Some of the higher court was like, sure, let him have his grandfather's money that he just killed. And the rest of them were like, no. That's sort of the first case in this lineage of cases, this 16-year-old kid who poisoned his grandfather. Now we're going to move into, some of you guys may have heard, because I think there's been documentaries about this. Some of you may have heard about the Son of Sam cases. So this guy, David Berkowitz, also in New York. I don't know what's going on in New York, but this case also came out of New York, the Son of Sam, right? So this is a guy, he was a serial killer in New York in the 90 years later, right? 90 years after Elmer killed his grandfather, fast forward. And there were cases in between, obviously, but these are kind of cited as the core cases. So in the 1970s, this guy, Son of Sam, he goes on a killing spree. If you have not seen the documentary about the Son of Sam, you need to check this guy out, because I think, anyway. So he goes and he kills all these people in New York, and the city is gripped by this. So it comes out that he had signed on to sell his story, that he was going to get paid all this money for book deals, movie rights, the whole thing. The New York legislature, they quickly scramble and they pass these Son of Sam laws. And the law basically says specifically that a criminal cannot sell their story, and that if they do, right, they cannot sell their story as a book, a movie, a magazine, whatever. And if they do sell their story, they have to turn over the proceeds to the state. And then the state will create almost like a victims compensation fund, right? And then the families of the victims, they can apply to get a part of this money. Okay, so, and that makes sense to us now. At the time, it was a big deal, right? So we know that serial killers should not get rich off of selling book deals. Now it is standard. Back then, it was not standard, okay? So this law stands for over a decade, that you cannot sell a book of your story. Now fast forward. In 1991, a gangster sells his story to Simon & Schuster. So, the publishing company, right? The publishing company decides that they're going to publish that story in a book called Wise Guy. The book Wise Guy became the movie Goodfellas. New York tried to take all the money for the book that became the movie Goodfellas. Long story short, a bunch of lawsuits back and forth. Now, here's the thing. Simon & Schuster had already paid for the rights to the book. And so they were being asked to turn over all of the profits from the book, because that was the rule based on the Son of Sam. That if any profit was made, all of that money had to be turned over to the state. Well, now Simon & Schuster is out their money. So it was actually the publishing company in this case that sued. Okay. It goes all the way up to the U.S. Supreme Court. It leaves New York and it goes to the Supreme Court. Unanimously, the Supreme Court strikes down the New York rule that says you cannot get rich by selling your book, and that the money has to go to the state if you do. The Supreme Court overturns that rule. So a lot of people think that that was the end of it, but it wasn't. What the Supreme Court said is, we agree with you that we agree with you that criminals should not be able to sell their story or write a book. We agree with you in principle, but the way you went about it was wrong. What you did by limiting your rule that criminals can't profit to speech, they can't profit off of speech, you're violating the First Amendment right to free speech. The Supreme Court says, but what you can do is you can say that a criminal can't profit in any way. What New York had said was, you cannot sell your story in a book, a magazine, a movie, etc., which is all speech. The Supreme Court said, we agree with you that criminals should not be able to profit, but you can't limit it to speech because that violates the First Amendment rule. So the principle survives, right? Now the US Congress, they narrow it and they say that based on the son of Sam laws, now the Congress makes a federal law and it says that nobody can profit in any way from their crime. Okay. So now this opens up the door for all kinds of other profit that gets blocked. This is how we get to this is how we're going to get to Chud the Builder. Okay, so the main case that came after, well, it actually didn't come after it. It was kind of in the same era. There's this case called Nebbia, US v. Nebbia, and this happened in 1966. Again, in New York. This was a massive drug dealer. He was arrested with 95 kilos of cocaine, which at the time in New York, that was the largest seizure of cocaine ever. This was a big, big case. So this guy, Nebbia, he said, I can't afford it. He keeps putting in all these motions to have his bail reduced. The court is not hearing it. The court is rejecting all of it. He puts in a series of things. And finally, the court is like, okay, enough. Your bail stands. It's $100,000, which, by the way, is approximately $1 million in 2026, right? The court says, enough of these requests for a bail reduction. I'm not reducing your bond. And I don't care if you're poor. You can just sit there. Well, no sooner than the judge says, I will hear no more of it, poof, out of nowhere comes $100,000 to pay this bail. His lawyer walks into court with basically a briefcase full of money, right? It wasn't a briefcase full of money. It was actually a certified check, but you get the picture. The lawyer, after doing all this wrangling, trying to get the bail cut down, the lawyer within hours walks back into the courthouse and says, here's this guy's check for $100,000. I'd like to take my client home. So the prosecutor jumps out. Wait a minute. Hold on. 2 hours ago, you said that you didn't have this money. You did all these motions. Now, all of a sudden, this magic money appears. The prosecutor says, Judge, we want to verify that these are not what we call ill-gotten funds, that this money is clean, that this money is not related to the 95 kilos that the guy is in jail for in the first place. And as a New York judge does, the judge says, no, I don't care where the money came from. Cash is cash. Put it in, take it to the window. So what basically was happening, and this is why people have a lot of problem with this rule. And I'm going to tell you how you see this every single day in courthouses across the country, right? Not always big cases, but every single day, prosecutors, they try to use this Nebbia thing. Basically, once the guy got the money, all of a sudden the prosecutor jumps in and moves the goalpost. He says, well, now wait a minute. We're not going to let you out because we want to verify the funds of it. The court shuts him down. The New York City judge is like, no, cash is cash. Take it to the window. So anyway, this leads all the way up to the U.S. Supreme Court because the state just cannot accept that this $100,000 poof came out of nowhere, right? They're calling it magic money. All right. And nobody knows where the money came from. To this day, nobody knows where this money came from. Okay. So naturally, the government wants to find out, where does it come to? Where does it come from? So what they did was they kept taking this thing all the way up to the Supreme Court to establish that the prosecution, the state, has a right to question the source of bail funds. Up until that point, they didn't have the right to question where the bail money came from. Now it's almost considered trite law that you can't rob a bank, get caught, and then use the money you stole from the bank teller or the bank vault to bail yourself out. We know this, but at that time, 50 years ago, this was novel. And had they not gone through all of the bail reduction requests, had they just paid it in the beginning, this case still might not have happened. But they made such a big deal about this guy was indigent. And then poof, the money shows up, right? So that's what brought this case up. This is the case that established that the state does have the right to challenge or question or make a defendant prove where the money came from. The court says the mere deposit of cash bail is not sufficient to deprive the court of the right to inquire into other factors which might bear on the question of the adequacy of the bail. In other words, this cash that popped up, this magic cash, is not actually all that magic, right? The court actually does have the right to look behind it. It is the role of the court, it is the role of the judge always to ensure the adequacy of bail. And that's a quote, adequacy. So the question is, what is the adequacy of bail? What makes bail adequate? It's not just the number. What makes bail adequate is that it is effective enough to ensure that the defendant comes back for the next trial date. It's not meant to be punitive. A lot of people think that, oh, this is a horrible crime, the bail should be higher. It's not meant to be punitive. It's meant to make sure that the person comes back. Now, why bigger charges with longer sentences might require more bail is because the longer your sentence that you're facing, the more likely you are to figure out a way to abscond. But the bail is not set. It's not technically set because of the nature of the crime. It's set because a higher possible sentence might make you get really creative. Okay. All right. So the court wants to make sure that the money did not come from criminal activity, drug proceeds, fraud, whatever, because there's this idea that is fraudulent, not fraudulent, that is false. I'm sorry. There's this idea that's false, that money that comes from crime is not as valued by the person, right? Now, that's possible, right? If you're some big drug dealer and you don't even see the money being made, then, it's a cost of doing business. But Nebia gets applied to a lot of people who they are actually out there working hard for those illegal proceeds. It actually is a job. There is blood, sweat, and tears in that money. So it is false to say that money that comes from crime is valued less because it doesn't really involve blood, sweat, and tears. We all know that it absolutely does involve blood, sweat, and tears. Okay. The other thing that Nebia did not say that the defendant always has to prove the source of funds in every case. It didn't create a blanket requirement. It just said that the court has the discretion, right, the authority to inquire about the source of the funds. The judge does not have to, according to Nebia. And most of the state rules related to this come from Nebia. Okay, so the fact that the judge has discretion means that the prosecution can argue for it and the defense can argue against it. And if you've been watching some of the Chud the Builder, you've seen both parties arguing about whether or not his give, send, go money should be allowed to be used, right? They are allowed to make arguments, and then the judge has the discretion to decide, yes, you have to prove it, or no, you can't prove it, okay? All right, so that hearing is called a Nebia hearing, right? So this is how it looks, okay? You're the defendant, the bail is set, you've got the money, or you've got people who are willing to put up the money. As soon as the judge says, okay, I give you 50,000, 100,000, a million, whatever it is, the prosecutor, and this is how it happens in real life. I have seen this hundreds of times, literally hundreds of times. The prosecutor jumps up and says, Your Honor, I'd like to request a Nebia hearing. Now, why do they do that? Oftentimes, it's not because they really care where the money came from. Because at the time the prosecutor requests the Nebia hearing, what had just happened? Defense counsel and the prosecutor had just been arguing back and forth, trying to convince the judge about what the bail should be. The prosecutor wanted no bail. So now they get bail. The prosecutor's upset, so they jump in and they want another bite at the apple. They request a Nebia hearing. So basically, that's their second opportunity to keep this guy in jail or this girl in jail. To me, it is so petty. It's almost like on a checklist for them. They really don't care where the money came from. It's not often enough money to even matter. They're just upset that you just got bail. So they're going to keep you in just a little bit longer by requesting this Nebia hearing. Okay, so then what does the defense counsel do? The judge says, sure, let's do a Nebia hearing. And again, for people who are just joining, the Nebia hearing is where the judge can look into the source of all these revenues that you're using for bail and decide yay or nay. Are they clean or are they not? And if they're not clean, they can't be used, right? Okay. So the judge grants the prosecutor's request. This guy's going back to jail. And then right? This is how it gets really, really petty. Then you have to schedule often the Nebbia hearing. So when does the prosecutor want the Nebbia hearing? Oh my God, Your Honor, I'm sorry. I'm booked all the way for another 60 days, which means your person is sitting in jail for 60 days, right? The defense is like, who didn't want the Nebbia hearing in the beginning, because now you've got all this extra work to do. They want to get it scheduled as quickly as they can get this information, right? So it's just one more place where they can go back and forth. Okay, so what does a defense counsel do? Defense counsel will file what's called a proffer. And all a proffer is, it's a statement of truth, right? It's you're proffering something to the court. Like you are asserting something to the court. It can be done in writing or it can be done orally. So in this case, the proffer is a written document, and it lays out in detail where the money came from that this defendant wants to use for their bail. Okay, so what kind of evidence could the defense use to prove the validity of this bail? Bank records, obviously, right? And the bank records have to go back far enough to trace the funds, right? If the funds were deposited 20 years ago, you've got to go back 20 years ago and show that deposit and where that deposit came from. If it was 4 months ago, you've got to show it, right? You can show income statements, pay stubs, tax returns, sometimes multiple years worth of tax returns. If the money came from a loan, you have to show the loan documents, the full agreement, the terms, the repayment schedule. If the bail money is coming from a family member, you have to show that family member has to prove the financial records, right? So this is whether the money comes from the defendant themselves or whether it comes from family or wherever it comes from, that person has to show the financial records, right? You could show property deeds, mortgage statements. You could show records from your business if you own a business. And it can include live testimony, right? People who know your finances, people who can get on the stand and testify under oath about, where the money came from, both your money or their own money, right? They can have to testify about it. So here's the thing. At this point, and now from the time they requested the Nebbia hearing until this document is produced, it could potentially be weeks that your client is still sitting there. So you write something thorough, and a lot of defense attorneys, they won't do Nebbia hearings because they're complicated, they're annoying. It's like managing a lot of pieces of paper, right? Some lawyers won't even touch it, which means you've also got to find a Nebbia attorney. Okay, so anyway, so you create this document, you've got all your attachments, etc. The prosecutor will look at it and say one of two things. Either, all right, we'll go for it, we'll agree, lift the Nebbia hold, let the guy pay the bond, and he goes home. And that can happen, whenever they get to reading your proffer. However, the prosecutor doesn't have to agree to what you wrote on the documents. The prosecutor could say, no, this still looks shady, let's do a hearing. And then again, they try to schedule it as far out into the future as they possibly can. So now you've got to have this hearing. The hearing is literally a hearing. Everybody comes to court. You've seen it in the Chud the Builder case. People come to court, they argue. Now the burden of proof is on the defendant, meaning the defendant is the one who has to show the source of the funds. It's not on the prosecutor. All right. And the standard is like a preponderance of the evidence. It's not a high standard. It's just kind of more likely than not that the funds are legitimate. All right. So what if you can't prove the source of your funds? You sit there. Even if you have the full amount of bail in cash, even if someone's already written the certified check, even if it's in an escrow account, it's ready to go. If you can't prove to the court and to the state the source of the funds, then the bail is what we call inadequate and you don't get released. I want to talk about who can trigger this hearing because there's a lot of confusion about this, right? Can the judge require a Nebbia hearing on his own, which basically there's a term called sua sponte, right? Can the judge require this hearing sua sponte, meaning on his own without a motion from the state? And the answer to that, unfortunately, is yes. But here's the thing. The prosecutor's authority to request the Nebbia hearing comes from the Nebbia case. The judge's ability to require a source of bail funds hearing doesn't quite come from the case. It comes from this long-standing duty of the court to establish the adequacy of bail. The prosecutor, which is the state, they can request this hearing based on this case Nebbia. The judge himself can request it based on the long-standing duty of judges to ensure the adequacy of bail. And remember, the adequacy means how likely it is to ensure that the defendant comes back. Okay, so they both sides can request it, but it comes from different sources of authority. But in practice, in real life, it's almost always the prosecutor who requests it. Sometimes for good grounds, I would say 75 to 85%, it's because they're upset that this guy just got granted bail. All right. Okay, so I want to give you an example. Now that I've sort of explained this lineage of how we get there, I want to explain to you how this appears. And I have dealt with Nebbia so many times I can't even express it to you. Okay, this is how it happens. A man and a woman are arrested together. Let's say it's a drug case, right? There's guns in the house, guns in the car, drugs in the house, drugs in the car, whatever it is. And bail gets set for both of them. You see their faces light up. They think they're going home. And then, like I said, poof, the prosecutor pops up out of their chair. Your Honor, I'd like to request a Nebbia hearing for both defendants, right? They want to know the source of the bail funds. What they're really mad about, again, is that this guy just got bail. This girl just got bail. But here's what happens next. And this is why I hate Nebbia so much. Because the man, who unfortunately is usually, right, 9 times out of 10, I know it's not always, but 9 times out of 10, the man is actually the owner of the guns and the drugs, right? It's the man whose name is on the lease. It's the man whose car it is. He's the person with the income. He's the person with the side business. He gets his Nebbia attorney really fast, and he'll be out in a couple of days. Probably because he already worked with an attorney, right? He's been working with this attorney for a long time. The woman who 9 times out of 10, now her case is going to get dismissed, but it'll take 6 or 8 months for it to be dismissed. She'll sit in jail the entire time. Not because her bail is higher, not because she's more dangerous, but because she doesn't have the money to get out. And the bail was set based on the severity of the other guy's, her boyfriend, the crime, the brother, right? I've seen cases where the girl literally just came over to the house shortly before. They're not even dating or anything. The raid happens and now she's in jail. And she's going to sit because she doesn't have the money. She doesn't have the bank records. She's not prepared for this eventuality, whereas his lawyer has been preparing him for it for years. The other thing is that she may have to get 5 or 6 people to come together to produce her bail. She's got to ask her mom, her 2 aunties, her uncle, and her boss to give an advance on her, her next paycheck or something like that. Now, all of these people have to prove the source of their funds to get her out. But what usually happens is not that. Usually the woman sits in jail for months. Even if her case ends up being dismissed later, she sits there for months with this Nebbia hearing looming over her head. That is not fair, but that is the practicality of how you see Nebbia show up in regular cases when the people are not drug lords, etc. Right? And Nebbia is very it's established law, right? But it's very controversial because a lot of times prosecutors use it as a weapon or a tool when they're upset that you just got bond. Also, oftentimes the woman will sit longer when it was her boyfriend's drugs. A lot of times she didn't even know the drugs were in the house, right? Or certainly not how much. And I know that women commit crimes, etc., right? The other thing is, rich people get out more easily when Nebbia is invoked. And I'm going to tell you why. If you come from a rich family and your mom or dad can write a single check to get you out, they've got the money, they've got a business, they've got, high paying jobs or something, they can easily make this proffer. They can easily prove the source of their funds. And it's only one person that has to prove it. Mom and dad are rich. And the children of affluent people commit a lot of crimes. And they get Nebbia hearings and they go very smoothly and those kids are home. But if you're poor and one person can't write the check and you've got to sort of get all of your family together to come in, you will sit there. Because even if your aunt is willing to give you $2,000 towards your bail, she is not interested in turning over all of her financial records, right? Even if your uncle is willing to put $5,000 on it, he's not really going to hand over his bank records and his tax returns and do right. He may or may not even know where they are. Okay, so that's the other thing, right? It creates these outcomes that are not fair. So let me tell you about two cases, right? We're going to start with Chud the Builder, right? So Dalton Etherly, and you probably know him as Chud the Builder. He's a controversial streamer. He does, a lot of race baiting type stuff. Anyway, he gets arrested earlier this year. He's charged with attempted murder, aggravated assault, reckless endangerment with a deadly weapon, employing a firearm, all this stuff. And he gets arrested. He goes to jail. Bail was set at $1 million. It had been $1.25 million. It gets reduced to $1 million to keep it in alignment with other similar cases, right? It was lowered to that because that was kind of the standard. All right. So his supporters, they come up with this Give, Send, Go, which they had started building even before the date of the shooting. So what happens in that case, the judge, right, based on this kind of nebula idea, the judge says that Chud the Builder cannot use any of the funds raised after May 13th. It was because the judge asserts, and it's probably 90% true, that the majority of the funds raised after that date were raised for his defense, his bond, etc. Some people may have been planning to give to him anyway, and they just didn't get to it until the 15th, right? So it wasn't 100% of the money, but the judge says that any of that money raised after cannot be used. And this is the judge saying that because thousands of people contributed money, we can't do hearings, we can't manage proffers from all of those people. We can't verify the source of those funds, right? The judge is not saying that the funds are not clean. The judge is simply saying that we can't verify whether or not they're clean. And then there's the whole issue of the judge capping the bail bond companies and all. That's a different issue. That's a different lineage of law. The judge is basically saying that bail money is profit. The ability to get out is profit, right? Because you can't profit from your crimes. So this is profit. This is equating bail with profit, getting out with profit, etc. Okay, so that's why Chud the Builder is still sitting in jail, because he can't prove the source of all of this money, right? This is direct nebula. Now, let's look at Carmelo Anthony, because his is a little bit different. Carmelo Anthony, and there's been a lot of rumor back and forth about what has happened to Carmelo's money. Has he ever used it? Did the family get any of it? They say they never got any of it. Some people say the lawyer has it. Some people say that early spokesperson has it. Nobody really knows what this is. But what we do know is that Give, Send, Go has now said that Carmelo can't use any of this money now that he's been convicted. Now, if you remember, originally, GoFundMe was the platform of choice until GoFundMe had to change their rules and say that we don't let people raise money, do fundraising when there's violence, when there's crime, when there's all right. They don't want to be associated with that. So then Give, Send, Go pops in and they say, hey, we'll do it. We'll do it. So then all of the high profile cases, they move over to Give, Send, Go. The reason that they're not giving Carmelo his money is they are saying that his use of the money now is outside of the scope of what it was originally raised for. Okay, so I want you to see two things here. The first one is that the judge can block, right? This is a double layer of denial of these funds. The judge can question the legitimacy of the funds, like where do they come from? Is this clean money or not? That's the first layer. So even if the platform says, yes, you can use it, as they have said in Chud the Builder's case, right? Give, Send, Go said in Chud the Builder's case, yes, you can use the money. Where he ran into problems was because the court said, no, you can't, because we can't verify where all those different sources of funds got their money. Carmelo, the court is not saying anything, but Give, Send, Go is saying that you raise this money for one thing, that matter is over, and now you want to use it for something else. Carmelo supporters are looking at the fine print in it, and it says they're saying that there's a broader usage, right? They put a lot of commas in it, right? So the lesson now, I guess, is if you raise money, you need to put a lot of commas in it, right? We want to use this money for this, the trial, the appeal, the pre-trial, the post-trial, whatever it is, right? So it's interesting, right? So Give Send Go is acting like this big hero. They're saying, well, we'll let you use this money for whatever your supporters want you to use it for, knowing that the courts can come right behind them and shut it down anyway. All right. So this is kind of the legacy of this area of law. You can't profit. We need to make sure that you're not profiting, and using this as bail money basically is profiting. All right, 13th juror. Hello. All right, so you're saying, good afternoon, Counsel Gray. This subject is timely. Thank you. Rob Reiner's son, who is charged with killing his parents, is trying to do just that. Yep, there's been some headlines about Rob Reiner's. For those of you that don't know, Rob Reiner is an old actor and Hollywood producing powerhouse. Rob Reiner was the son in All in the Family, I think. I think that's the name of the show, All in the Family, years and years ago. Oh, he wants to. Okay. So when did you put this in here? Okay, so you're going back. So you're saying, and I didn't know this about Rob Reiner, but I'm going to go on what this commenter is saying. So this commenter is saying that Rob Reiner is trying to use his trust fund is he trying to get out of jail, or is he trying to pay for his legal work? I don't know. But that does raise an interesting legal question. Again, I have not followed the Rob Reiner case, but it could be that he might be blocked from using his trust fund if the source of the trust fund money came from his parents that he's now accused of killing. I don't know. I'm not following it, like I said. Okay, so anyway, so I just wanted to let you guys know that these cases don't come out of nowhere. They're not based on the whimsy of the judge. They're not based on anybody, any racist, liberal, conservative, black, white. It's not based on that. The American courts have been grappling with this question of what types of funds and what sources of funds can be. So here's the other piece, and I didn't go into this, but I will. Okay, so there's two things, right? So when the law says that you can't profit from your wrongdoing, that money can go to one of two places. It can go to the criminal who did it, or it can be somehow funneled into the court as a bail payment. And there have been cases where people who are in the money laundering business will try to launder money through bail, right? And basically all laundering money means is that you put dirty money in, it spins around a couple times, and clean money comes out. So how does that work when it's bail? Dirty money goes into the bail, it turns around. When the defendant presents himself again, that money comes back out from the court in the form of a check, right? The court literally would be participating in laundering money if they accepted dirty money in and then wrote it back out as a clean check to be deposited anywhere, right? So the court, you can't make the court participate in laundering money. Okay, so that's all I have about this. I just wanted you guys, like I said, to understand the lineage of this area of law. The court has been chewing on this for well over 100 years. Every case where this matter comes up, they're always colorful cases. You guys, let me know also in the chat, if you're watching the replay, let me know, are you interested in the fact patterns of some of these crazy old cases? Because our laws, they don't come from nothing. They come from the courts and the legislatures trying to stay one step ahead of the crazy people, the criminal people, right? Everybody's just trying to stay one step ahead of them. And the reason that cases make it to the Supreme Court in the first place is because we've never had to answer this question before. Like, this is literally the first time we've had to decide this. Then it goes to the Supreme Court. The Supreme Court will make the decision, or they'll send it to the legislature and tell them to make the decision. So basically, we're constantly just trying to keep up with the people who are pushing the rules and pushing the rules. And over time, we do get it right. I am a person who believes that over time, bad laws get corrected. Laws that are too broad get narrowed. Laws that are too narrow, they get broadened. I am a person who I do believe, and not everyone believes this, but I do believe that the law in this country, based on the legal processes that we've got, that, like I've said, the rest of the world is envious of, we do get it right over time. So anyway, that's all I've got. Thanks for tuning in live for those of you that were able to get here. I appreciate you guys. All right, have a good one.